All right, everyone, just give me one moment, please.
Hello, Your Honor. Hey, what day were you released from the hospital?
All right, everyone, we are back. I'm hoping that everyone had a great little break. All right, John Pettis.
Yes, Judge, I'm here on Jonathan Boyd. No relation.
No relation, that's true.
I had a chance to speak to David on this one. The forensics are supposed to still do, they're supposed to investigate his laptop that they confiscated. That still has not been given over to the DA's office, so it hasn't been granted over to us, so we're still waiting on some discovery.
So the laptop is actually with the arresting authority? Where's the laptop?
I have an email out, Judge, to find out exactly where it is. Depending on what they have to do to it, a lot of times that gets outsourced to either the FBI or the Secret Service.
Okay.
So,
All right. So Norma, on Jonathan Boyd,
Yes, ma'am.
can we have a 60-day reset for discovery?
Yes, ma'am.
I think that should be enough time for us to discover where the laptop is.
I would
And
hope
then
so.
we'll go.
I hope so too, yes.
I'm going to write on the docket sheet, you know, the facial expressions and that you all said, I hope so. Like that means it will be here.
I have no control over that, Judge. If I had control over it, I don't know.
Judge, I can do, I'm sorry to interrupt. I can
Yeah,
do
go ahead.
November 12th or November 15th.
Uh, 12th is good.
All right. We will see you back on November 12th. And you
Perfect.
all may have to do a road trip. Get that computer.
Thank you, Judge. May I be excused?
Yes, you're excused.
Thank you.
You're welcome. Ed Bartholomew.
Mr. Hernandez, Your Honor, update.
Yes, what is the
Continues to remain
update?
hospitalized and on dialysis, is my understanding.
I'm sorry, what did you say?
Continues on dialysis.
Well, is he in a hospital or is he not in a hospital?
He's, ma'am, your office just text my client's wife to have her contact me. She has not contacted me at this date. So the last update I had is home on dialysis.
So he's no longer in the hospital?
I have no current update as of this moment.
Okay, we'll come back to you, see if you can get an up.
Judge, I can't get an update. She's never answered me, and I don't have a phone number for her. And this is her. Just 1 second. All right, I'll be right back.
Thank you. And does anyone know if the plea has been taken care of in County Court number 1 on James Seeloff client? on Raymond Bird?
I have not heard back from the coordinator, Judge.
All right, thank you.
And Judge, can I,
Yes.
she still hasn't texted me back. Can I come back to you Monday morning?
All right, this is what we're gonna do. We're gonna recall this for Monday. And if I don't have any documentation or your client doesn't appear, I'll hear whatever motions that the state wants to present.
I'm in Wilson County first thing, Judge, so I'll be a little late.
No problem.
Thank you,
So
Judge.
we'll recall it for Monday.
I appreciate the court's consideration, Your Honor, and we'll see if she gets a hold of me. I have her, she's supposed to contact me. Thank you.
All right, we'll recall it for the 13th.
Thank you. And thank Norma too for doing the forward to her. There we go.
All right, and then Norma, can you get Mr. Orta back here, please? So that we don't, are not here after hours. And then are the parties ready on Ms. Gay's case?
Your Honor, I'm ready.
Yes, Judge.
Okay. Let's see if this system wants to work, Brenna. Oh my gosh, it works. Mr. Owens, you need to show your video. And everyone, just give me one moment. Right. All right, the court is going to call 2021 CR 1906, State of Texas versus Kevin Owens. Can I have parties announced for the record, please, for the state,
Hunter Morris.
for the defense?
And Gay,
And are you Mr. Owens?
Yes.
We're proceeding by video because of the pandemic. Any objections from the state?
None from the state, Judge.
Any objections from the defense?
no objection.
Mr. Owens, do you have any objection to this hearing taking place by video?
No.
All right, everyone, just one moment. Mr. Orta has just arrived. Mr. Orta? Your client is not here yet. Mr. Orta,
Yes,
your client is not on yet, but my understanding there's an agreement.
yes, the paperwork should be there also. I don't know.
All right, I'm gonna send your client to breakout room number 1.
Okay,
And I see she's in one of the breakout rooms, and I'll send you to number 1.
thank you, Judge.
You're welcome.
Yeah.
All right, we're back on the record. The defense has filed a motion, a writ of habeas corpus motion. State has filed an answer. Defense, have you had a chance to review the state's answer?
Yes, I received it 2 days ago, and I've had an opportunity to review it.
All right. And defense, did you have a chance to review the defense's motion?
The state did have the opportunity to review.
I'm
the
sorry.
motion.
Thank you, state. Yes. All right. Defense, it's your motion. You may proceed.
Yes, Your Honor. On behalf of Mr. Owens, I filed a writ of habeas corpus. He has been charged under section 42.072 of the Texas Penal Code, commonly referred to as the stalking statute. We filed this writ because we believe that the indictment that he committed an offense, that the state, that he did not commit the offense.
And Ms. Gay, I'm sorry to interrupt you. Before we go into your argument on this case, it needs to be noted that you're challenging the constitutionality of the statute. Is that correct? Oh, I'm sorry, we can't hear you.
Correct.
Right. And state, was the Attorney General's office notified?
Yes, Judge. I made contact with a Carolyn Meredith at the Attorney General's office yesterday, and we did discuss this. They are aware. And
All
it
right.
did not sound like they had a problem with us proceeding.
All right. All right. And then I'm sorry, back to you, Ms. Gay.
Thank you, Your Honor. It appears that the defendant will show that on the face of the indictment that he has not committed an offense against the laws of the state of Texas, specifically section 42.072, commonly referred to as the stalking statute. That this statute, this specific statute, is unconstitutional because it's facially overbroad restriction on speech in violation of the free speech clause of the First Amendment of the United States Constitution, Your Honor. Would the court want me to just do an overview or just go through it?
Oh, no, just state your argument
Okay.
for the record.
Thank you. Your Honor, we'd ask that the court take judicial notice of the court's file, which includes the indictment in this case.
All right, the court is reviewing the indictment. You may proceed.
Is the court taking judicial notice
Yes,
of the
the
file?
court is reviewing the indictment.
Okay. Your Honor, when you look at the indictment in this case and you juxtapose the stalking statute next to it, 42.072, you will see that the language in the statute is overly broad and offends our Constitution, our free speech, Your Honor. And what makes this implicate the free speech is that it implicates what's protected under the First Amendment, and it's overbroad in that it implicates this expressive conduct, symbolic conduct, as opposed and speech.
Ms. Gay, I'm sorry to interrupt you again. There's something happening with your sound. You're going in and out on your end, and it's making it difficult for the court reporter to hear and for me to hear.
I don't know what I can do differently, Your Honor.
Do you want to try logging out and log back in?
I'll try that.
Okay. And to the clerk, could you go to breakout room number 1? I've signed the paperwork on Miss Spiller.
Thank you, Judge.
Okay. All right, Ms. Gay.
Yes, Your Honor?
Okay, that is much better.
Okay.
All right, you can continue.
Your Honor, as here in this statute, when the statute restricts real and substantial amount of protected speech, inquiry ends, the court cannot consider anything else, and the statute is unconstitutional. This statute specifically looks at conduct that is threatening, which causes another person to feel uncomfortable, an uncomfortable emotion that what they feel. It's a feeling statute, as opposed to a statute that requires actual threats. Now, when the state indicted my client, they tiptoed around the public harassment statute, which is Texas Penal Code 42.07, which precedes the stalking statute in the code. And when you look at Chapter 42.072 stalking statute, you'll see it references the public harassment, that harassment chart wording in here, and in some manner it reflects that harassment statute. Okay, and that harassment statute has been found unconstitutional according to the Second Court of Appeals, and there's a PDR pending. So under Ex parte Barton, B-A-R-T-O-N. So this stalking statute incorporates what one court has found to be unconstitutional. Now, in this statute here, like I said, it's a feeling statute. So it's not a reasonable person. It doesn't talk about direct actual threat. The statute doesn't do that. It's what this person feels. So by way of example, Your Honor, you or I could be held stalking somebody because we said to them, I'm going to make you pay. And that person perceives that as a threat. Or I'm going to put a curse on you. And that person perceives that as a threat of bodily injury. Because this statute is so overbroad and offends our constitutional rights of free speech, the fact that it can be interpreted that way, that is overbroad. And Your Honor, we're asking you to apply strict scrutiny and find this statute unconstitutional. But let's look a little bit further. Now, in other statutes, just say the terroristic threat statute under Penal Code 22.07, it has a definition of what an actual threat is. A threat of violence to any person or property that would place any person in fear of imminent serious bodily injury. That is much clearer as to what a threat is. Now, the stalking statute doesn't do that. It's conduct, which conduct can be telephone call, email, responding to the internet, that directed specifically at another, and that person, that the actor knows or reasonably should know the other person will regard as threatening. And in this case, when you look at the indictment just says verbal threats through electronic communications. By way of background, Your Honor, I have Exhibit A and B, which I had previously forwarded to the state and to the court reporter. One is it is a hearing transcript of the principle of AMA behavioral therapy, and B is the telephone calls.
And Judge, the state objects to all exhibits.
Let me just finish, Hunter.
Just one moment, everyone. So which exhibits are they? You say exhibits?
A and B.
Okay. And are you offering that into evidence?
Yes. One is a transcript of the principle Andrea Alvarez, who is the complaining witness listed in the indictment. It is a transcript from a hearing that occurred in County Court 11. And B is audios that were omitted that are referenced in the transcript that are calls, Your Honor. And I'd like to give you, by way of background, who this person is, how this all fits in, by way of background to the court.
So here's the question. The court does not have exhibits, defense exhibits A or B to review. Once I have those to review, then if the state has an objection to those being admitted, then the court will hear those objections, but I can't make a reasoned ruling on the state's objections till the court has those exhibits.
And I apologize. I thought I CC'd Norma, but I may not have. Let me just pop into the email. I know that Brianna, hopefully she did get them, but let me check over to my exhibits.
I can also try and send those, Judge.
All right. Well, Mr. Morris, if you'll just send those to the court and include Ms. Gay in the email.
Can do that, Judge.
Thank you.
To Norma, but you may, I don't know if you're sending it to Lupe.
No, he'll be sending the directly to me.
I just forwarded what I believe are the exhibits she's referring to. They were the ones, Ms. Gay, that you sent me 2 days ago in a zip folder.
Okay, so what I have is the zip. Well, let me share screen so everyone will know what I have. This is what's been sent to the court, Ms. Gay, so that you'll see what I have.
Yes, Your Honor.
All right, then just give me a moment to look at that. Okay. The court has reviewed defenses exhibits B and B, I believe is a transcript. Defense exhibit A, the court is unable to open. But yes, it will not open, Ms. Gay. And I think that has to do with the protection on my system. So everyone, with regards, let me hear the arguments with regards to defense exhibit B, which is the transcript. Ms. Gay, you're offering defense exhibit B?
You're muted.
You're muted, Arlene.
Exhibit B is a transcript of the complaining witness and where she attends a hearing and discusses the conduct of Mr. Owens.
Okay, you're offering that exhibit?
Yes, Your Honor.
All right, state what's the objection?
Judge, pretrial writ of habeas corpus, as you may have seen in the state's response, can only be used as a means of challenging the facial validity of the statute. And by introducing exhibits for the purposes of testimony and factual information, we would necessarily be moving into an as-applied analysis, which is not appropriate for a pretrial writ. The state objects to the introduction of testimony as it relates to the facts, because the challenge in this case is only appropriate pretrial if it's a facial challenge, and the facial challenge can be handled by argument and by review of the indictment itself, not testimony.
All right, state's objection to defense exhibit B will be sustained. And
Your
everyone,
Honor,
yes,
I'm sorry.
Ms. Gay?
I'd like to just respond that
Yes,
the difference is me discussing some factual backgrounds that the court may want to be aware of, like who the person is and the parties and how they relate, Your Honor, and that's what that's being offered for, is to aid the court.
all right. The state's objection to that exhibit will be sustained. And if everyone will just give me a moment with regards to defense exhibit A. All right, the court was able to hear defense's exhibit A. Defense, are you offering exhibit A into evidence?
Yes, Your Honor, I'm offering it to add context to the speech in question, that the court knows the conduct, the speech, and the relationship of the parties.
All right, state, any objections?
Yes, Judge, the state objects. Defense in the movement in a situation as this is required to show that the statute being challenged facially is void in all respects based on the argument and the indictment. And the facts are unnecessary in such a burden. And this would necessarily move us from a facial challenge to an as-applied challenge. So the state objects.
All right, defense response.
Your Honor, like I said, we're trying to aid the court in determining the conduct that is threatening and aid the court to show that speech that may invoke an emotion of fear because of its context is overly broad. And we're giving this information to the court so they can look and appreciate that there are speech out there that, when you apply this statute, is overly broad and violates the First Amendment.
All right.
And Judge, if I may, in
Yes.
defense's own words, when applied.
All right. State's objection will be sustained. Any other argument, defense?
No, Your Honor.
All right, state, I'll hear a response.
Yes, Judge, as the state already mentioned, a pretrial writ of habeas corpus is appropriate to challenge the constitutionality of the statute only in the facial challenge.
Your Honor, I misunderstood. Did you say that, are you done, Ms. Gay?
Yes.
Or were you
yes.
relating to the objection? Oh, I misunderstood because it came on the heels of the objection.
No problem.
No, I'm not done. Sorry.
Okay, all right, continue.
Okay, thank you. And so the state does not have, government does not have a compelling state interest in this speech, Your Honor. This speech, as alleged in the indictment, is verbal communications through, verbal threats through electronic communications. That the conduct, the statute says the conduct, and here they're saying the speech. Any conduct, which includes speech, that may be threatening to another, makes them feel threatened, makes them feel that they're afraid, is content-based speech. So I think that is a given for the court to accept. I don't think that the state is opposed to that argument or believes that the conduct, which is speech in this case, is content-based. So when we look at any restriction, a restriction of conduct that causes emotion restricts speech based upon its content, excuse me. So the state was going to argue that this is a reasonable restriction on speech. We're saying, no, it's not a reasonable restriction on speech because it's the speech, which is based on emotion, restricts speech based on its content. So we're looking at the content of the speech, the verbal threats. And speech, we agree with the state on one respect, that if you're making a true threat, they cite Virginia versus Black, a true threat is different. And I addressed that in my writ, but that is not what we're talking about here. This statute says conduct that this other person feels in fear, feels that they're threatened. And that's the problem with the statute, is any speech that a person interprets as being threatening, you're now looking at a third-degree felony. And I don't believe that's the intent of the legislation in this case, is to make free speech, whether it's on any type of communication platform, whether it's by the telephone, any form whatsoever. If it restricts reasonable speech, not a true threat, then this statute's overbroad. And like I said, the harassment statute's been found unconstitutional and pending PDR. So this is what this statute does. It takes anything that is everyday conversation, even in court. If a defendant has multiple calls to the court, they could be arrested asking for, wanting to come down there. The court could look at that. The district clerk could look at that and say, well, that's harassing. And that's stalking because you did it more than 2 times. So, Your Honor, threatening speech is, in this statute, it's not the eyes of the beholder, it's the ears of the beholder. And that's what makes this statute so dangerous for anybody, for any citizen. So So when, in this case, and in the statute is devoid of words such as what is contained within the terroristic threat statute that I previously mentioned, that it does not delineate true threats from just regular day conversation. I've given you some examples of that. So the question in this statute is the question of specific intent of whether a statute passes constitutional scrutiny. No one is arguing that true threats should be illegal. It's when they're not true threats and everyday conversation. And that is what this statute, why it is unconstitutional, because it evades free speech. I've given you some examples that, if said, and we know, I will ruin you, I'll bury you, those words like that, if a person thinks that they're threatening, even though there's no true threat, it implicates the stalking statute. And that's why it takes free speech, protected constitutional free speech, and turns it into a criminal case, Your Honor. And also, the statute, although it talks as conduct includes speech, and the statute does not limit itself to any specific form of communication. The statute does not require that actually the communication be sent directly to the individual. And also, the statute itself it doesn't limit itself to communications that invades anyone's substantial privacy rights. The state relies heavily on that argument in their reply to the writ, the privacy issue of the complaining witness in this case. The complaining witness in this case owns a business. So the state argues the complaining witness's privacy rights, but we have free speech, and we can communicate with others in different types of communication, and even through a telephone call. And although that person may say it's annoying or I don't like it, but when you do that, how does that invade someone's privacy rights? The person has a right to not answer the phone. More importantly, is these communications, predominant communications occurred at a business, which the complaining witness is a principal of. So this person receives communications. So the statute doesn't say evades privacy. We already know that being annoying is not against the law. Multiple calls to a business is not against the law. It is the statute and the areas where it restricts content, and that this statute is unconstitutional in this case. I believe that's what I have. I'll pass the floor.
Mr. Morris?
Yes, Judge. As I began to say earlier, a pretrial writ of habeas corpus is only an avenue to challenge the constitutionality of a statute if it's a facial challenge. As applied challenges are better with the developed record at trial for the appellate court to hear. And that is something stated by the Supreme Court, or the Court of Criminal Appeals of Texas, Judge. So a facial challenge is the only challenge appropriate here on the constitutionality of the statute. The movement challenging the constitutionality must show that the statute is overbroad in all of its regards and application. But the movement in this case has omitted 2 sections from the stalking statute and their filing. A2 and 3, excuse me. And the petitioner also argues that it's a entirely subjective statute based on the feelings of the complainant, yet in the statute cited in the filing and in the indictment itself, Judge, it includes the element of the actor knowing or reasonably should know the other person will regard the speech as threatening. And he doesn't enjoy the same freedom of speech when leaving voicemails on a person's phone as he would if he's on the steps of City Hall. The forum matters. And a statute's not rendered unconstitutionally vague merely because words or terms are not specifically defined, as the petitioner also said in the terroristic threat case. So just because a true threat is not defined does not make the statute unconstitutionally vague, and vagueness wasn't even argued, but that was brought up in argument. This statute specifically has been challenged for overbreadth before, and I have a case pulled up here. Ploger versus State Judge, that's 189 Southwest 3rd at 799, where, and this is post-conviction, an appellant argued that the stalking statute was facially overbroad because it did not describe the type of conduct that was prohibited. It didn't define the term following and allowed non-threatening conduct to be encompassed in the statute, and the court said the statute was not overbroad facially. It's the same statute. There was another iteration in 2013 that has not been challenged as far as its overbreadth, or at least the statute stands. And this argument will be better suited following a full record created at trial on an as-applied challenge.
All right. Any response, Ms. Gay?
Your Honor, I disagree with the state. I already mentioned ex parte Barton and declared part of this when it relies upon 4207 as unconstitutional. Yes, it's pending, Your Honor, but this statute is a feeling statute, and it does not have a reasonable person standard. Okay, it does not say what a reasonable person would find as threatening. Our other statutes, like the terroristic threat, again, defines what a threat is. This leads into interpretation. It's content-based. It relies on conduct that could, by my examples, cause someone to be prosecuted. And due to the way that it's written, the way that it has no reasonable person, it's not reasonable what a reasonable person would be. It's the type of content, the content of the speech. It relies upon an emotion by the hearer, by the person that hears it, and which makes it overly broad. It implicates free speech. It implicates non-threatening, what a reasonable person would consider non-threatening speech. And we believe on its face, it's unconstitutional.
All right, thank you. All right, the court has heard the arguments from both sides. Defense's motion will be denied. Is there anything else with regards to this motion? I'm sorry, Ms. Gay, you're on mute.
Thank you. As part of the record, I'd like Exhibit A and B to be attached. I'll be providing a gist to Brianna, so she can put it as part of it, of the record. I'll be
All right.
to her.
And then, Ms. Gay, have you received all discovery in this case?
I don't believe so. I don't believe that I received the 911 call.
All right, Norma, can I have a reset date on this case in 3 weeks for discovery? Mr. Morris, do you all have the 911 call?
Let me check, Judge.
Judge, I can do October 4th.
Your Honor,
Yes.
not to jump in ahead of you, but I'm on vacation that day.
Oh, no problem. Well, please enjoy your vacation. Hopefully, where are you going?
Colorado,
Oh,
so, the elk are in the rut. So it's
okay.
So you see, they all come out of the woods and you actually get to see them.
Well, I
And,
think they want some privacy.
yeah, it's pretty interesting when the elk and their harem it's actually called a harem of the elk. It's pretty interesting, and it's also hopefully going to be beautiful weather, leaves changing.
Okay, awesome. So when will you be coming back?
I will be back on the 8th, which is a Friday.
All right, Norma, can we set it after the 8th?
Yes, ma'am.
What date?
I can do that Monday, the 11th.
Okay, we'll come back on October 11th and make sure you have all discovery.
Okay.
Is there anything else from either side?
Judge, I'm looking in this case as e-discovery, and I'm not seeing 911 audio. So I'll inspect the physical file to see if there's something that just has not made it in e-discovery. And Arlene, if you feel like there's something else that you're missing, you have my email. Just let me know.
And I want to clarify. I said 911. It's 311. I'm sorry. It's 311.
It's what? 311?
311. I said 911, but it's 311.
Okay. The tip line.
Yeah. Well, I don't consider that a tip line, but I'll go with that. That's Crime Stopper. That's where you get the money. Okay. But I think it came in through the 311.
Okay.
All right.
There is a 911, but there may be 911. So if you don't mind checking both.
Sure. Can you send me an email to that effect?
Sure.
Thank you.
Okay.
All right, thank you. Then you and your client, Mr. Owens, are excused, Ms. Gay.
Okay. Thank you.
You're welcome. Who are the parties on Delphina Spiller?
Judge, I'm
Senator
gonna send you a
Morris,
chat.
Okay. Let me find Ms. Orta. Mr. Orta, there you are. All right, the court is calling 2021 CR 5216, State of Texas versus Delphina Spiller. Can I have parties announced for the record, please, for the state,
Senator Morris.
for the defense?
Romaldo Horta representing Ms. Spiller, Your Honor.
And are you Delphina Spiller?
Yes, I am.
We're proceeding by video because of the pandemic. Any objections from the state?
None, Judge.
Any objections from the defense?
No, Your Honor.
Ms. Spiller, I'm going to show you what's entitled Defendant's Consent to Appear by Video Conference. Did you review that document with your attorney? Did you understand it? And did you
Yes.
electronically sign it?
Yes, I did.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, I did.
Counsel, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Spiller, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on indictment as presented?
Yes, Judge.
Ms. Spiller, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, I did.
Again, did you understand what you're charged with is possession of a controlled substance, penalty group 1, 4 grams to 200 grams? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, I did.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I do.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, I do.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, I do.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, I do.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, I do.
Counsel, has your client been able to provide any defenses to this offense?
Yes, yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes,
Ms. Filler, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No,
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
no.
Are you satisfied with the way you've been represented?
Yes, I am.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that page with your attorney and did you understand it?
Yes, I did.
All right, everyone,
I had
we're gonna-
a question.
Just one
Go ahead.
moment. Everyone, we're going to take a 5-minute break. Brenda, I'm sorry, I just saw your chat.
It's okay, keep going.
Okay.
Okay.
All right. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I did.
All right. According to the plea bargain agreement, there's a $500 fine. The state recommends deferred adjudication. The state will take in consideration the following CM numbers: 89335, 89336, 89337. There's restitution of $57 for laboratory testing. The MRT, no contact with the complainants listed in CM 89335. Elva Tool, ELVA, last name TOOLE. Robert Sosa, SOSA. Lawrence Doherty, DOUGHERTY. Did you understand that to be the plea bargain agreement?
Yes, I did.
Defense, is that the plea bargain agreement?
yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge, and I just note that the individuals named in the no contact term are those in that CM number.
All right, and is that Elva Tool, Robert Sosa, and Lawrence Doherty?
Correct, Judge, that's all the same thing.
All right, thank you. I'm going to show you the paragraph entitled Waiver of Appeal. Ms. Spiller, did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I do.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 5 years. There'll be a TAP evaluation, 120 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
I'm sorry?
I said, yes, I do.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's no contest plea?
It offers states one and attachments, Judge.
Any objections?
No, Your Honor.
Ms. Bill, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, I do.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, I'd just like the court to consider the offer from the state. She has never been convicted of anything, and I know that she'll comply with everything on probation and complete it satisfactory.
Ms. Spiller, who is Philip Manuel Aguilar?
He was a gentleman that I dated briefly last year.
And if you're drug tested today, what are the results going to be?
They'll be negative.
All right, you know you're going to get drug tested today, right?
Okay, yes, ma'am.
All right, so you're still saying they're going to be negative?
Yes, ma'am.
Okay, when's the last time you used?
I was probably a couple of months ago before my last arrest.
What have you been using?
I was still using methamphetamines.
All right, you appear sort of jittery today to me.
I'm sorry, I'm just nervous. This is a big deal for me. I didn't really, was
All right,
reluctant to sign and.
No. Let's not pull that nonsense, right? Because I read the police report, and in the police report, you signed the form that states that the drugs in the vehicle were yours. You signed the consent form. So here's the thing. I've been a defense attorney. I've been a prosecutor. Once you end up pleading to something and you're asking the court to give you deferred, now's the time for truth and honesty.
Okay.
And this is why I say that. I want you to, if I'm going to give you deferred, that means that I think that you can be successful on it. I want you to be successful on it. I hate when people come back and there are some issues, or I feel saddened by the fact that they're coming back because they haven't done what they're supposed to do. So we're going to start over with all of my questions. I need you to be honest with me so that I can give you conditions to help you be successful. All right?
Yes, ma'am.
Okay. So that's all I'm trying to do. That's what my questions are designed to do.
Okay.
So, number one, when's the last time you had contact with Philip Aguilar?
November maybe of last year.
Right.
Physical contact. He's texted me and stuff since this year he has.
Okay. So do you all have children together or anything like that?
No, we don't. No, we don't.
Are you all still in a relationship?
No, we're not. He's in another state.
How old are you?
I am 39 years old.
Do you have any children?
Yes, I do.
What
I
are
have
their
two
ages?
daughters. One is 23 and the other one is about to be 8.
Okay. And does the 8-year-old live with you?
No, she does not. She resides with my husband in Spring Branch.
Okay. And why isn't your 8-year-old living with you? Has Child Protective Services been involved?
Yes, there was an incident with my older daughter that removed her from living with me.
Okay. When's the last time you had employment?
It's been a while. I was self-employed, like caring for, my niece and stuff for my sister while she worked. But since COVID, it's been pretty much just unemployed. Okay.
And when's the last time you used?
I used before I went to jail on the 11th of August. I'm sorry.
Okay, so you're telling me you haven't used since August, not anything?
Yes, ma'am. Well, since August 11th, or the day I went to jail. Yes, ma'am.
So there should be no marijuana, no cocaine, no meth, no
ma'am.
heroin or anything. All right,
No,
because I'm
ma'am.
gonna have you drug tested today, okay?
Okay.
How are you supporting yourself?
I was receiving unemployment, but that has stopped. And so now I'm looking for work. I've applied for like rental assistance but I haven't received anything yet. So just starting fresh.
Okay. All right, this is what the court is going to do. $500 fine, probated. 5 years deferred adjudication. Take in consideration the following CM numbers: 89335, 89336, 89337. Restitution for laboratory testing of $57. The MRT. No contact with Elva Tool, Robert Sosa, Lawrence Doherty, 120 hours of community service restitution. I'll waive 40 of that if you obtain the vaccine. I'm not ordering you to get the vaccine. It's completely up to you whether you do or not. But if you do, 40 hours will be deducted. Or if you've already obtained the vaccine, provide proof to probation and 40 hours will be deducted.
Okay, thank you.
You're welcome. Proof of employment within 30 days. There's to be no employment. And I want you to hear me on this. No employment as a home health care provider or anything that involves minors. So there's to be no more babysitting for you. You understand?
Okay. Yes, ma'am.
There's going to be regular reporting by Zoom. If you can't report by Zoom, then it'll have to be in person. Parenting classes. Random field visits 2 times per month. I'm going to want a UA
Yes, ma'am.
let me do it on September 13th. It's too late today. Is that correct, Ms. Reyes? I'm going to want a UA on September 13th by 9 a.m. So
Yes,
you
ma'am.
need to be there when the door is open.
Yes, ma'am.
Outpatient treatment with probation. Rebecca, is there anything else she needs?
No, ma'am.
Ms. Spiller, is there anything else you need from the court in order to be successful in this deferred adjudication?
No, not that I can think of.
All right, Ms. Spiller, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, I did.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, I do.
All right, we can go off the record. Ms. Spiller,
Yes,
you need
ma'am.
to make sure that you do everything that's being required of you. The key to success on probation is communication with your probation officer. You understand?
Yes, I do.
All right, I'm going to send you to breakout room number 2. Probation will meet you there.
Okay, thank you.
You're welcome. And Mr. Orta, you can be excused.
Judge, probation will provide her address, right?
Yes.
Okay, and just another thing, what do you call it? Last time you were on Zoom, you were talking about kids not knowing how to write cursive.
Yes.
Okay, the other thing that they don't know how to do is the Roman numerals. They don't even know what they are.
Yeah. Okay, that is shocking.
Yeah, because my son was looking at Super Bowl and said Super Bowl XX something. I can't read it 3 years ago. He said, "Don't you know your Roman numerals?" I told her what it was, and he said, "Don't you know your Roman numerals?" No, they don't teach them either.
Oh my gosh. Oh,
Yep.
Thanks for letting me know.
So if somebody gets an XL, whatever, they're not gonna know what it is.
Okay. All right. Thanks. Have a good one. You take care of
Bye,
yourself.
bye. Thank you, Judge. Might be excused.
Yes, bye-bye.
Thank you. Bye. Oh, another thing. Can you hear me?
Yes.
People don't take that vaccine serious. My brother-in-law just passed away with that last night.
Oh, I'm
And
so
he
sorry to
didn't-
hear that.
And the whole family, my sister and them were against it. So I know that's a big price to pay.
Yes. Oh, I'm sorry to hear that. If you need anything, just let us know, all right?
No problem. Thank you, Judge. Might be excused.
Yes, thank you.
Bye.
Bye-bye. All right, Norma, do you know if Raymond Bird's case was taken care of? Does anyone know?
Yes, it
Missed-
was.
Okay, great.
I submitted the dismissal.
Okay, thank you so much. All right, everyone, it is Friday and that was our last case. So I'm gonna stop live stream. Bye, everyone.
Is Timothy still here?
I'm sorry, who?
Is Timothy still on?